And since no additional request for an extension has been received, the board is required to act on both applications this evening. Otherwise, they would be deemed approved. So first, I would request a motion from the board to open the conditional use hearing.
I'll make that motion.
Second.
All in favor?
Aye.
Aye.
The conditional use, actually, the conditional use application was amended after the October 25, 2022 Planning Commission meeting. The initial request for conditional use approval was to permit construction of stormwater management facilities in areas of 15% to 25% steep slopes, and to permit substantial property improvements within the Tohickon Creek Watershed Overlay District. Subsequently, it was amended to permit a replacement sewage system in an area otherwise prohibited as a result of the ordinances of the township, and a second amended conditional use was requested to permit a future reserve septic system, stormwater system, and outlet structure, in addition to a portion of the parking lot and retaining wall to be located in zone 2 and 3 riparian buffers. With that having been said, is there anyone here this evening on behalf of Trenton Farms to present evidence in the conditional use hearing? I see no one raising their hand. Therefore, I would recommend to the Board of Supervisors, as there has been no evidence introduced to support the conditional use application, that it be denied for the reasons set forth in the Planning Commission's minutes, the Township Engineer's review letter, and the simple fact that no evidence has been presented to establish compliance with the requirements for a conditional use for any of the 4 conditional uses requested.
I'll make that motion.
I'll second.
All in favor for denial?
Aye.
Aye.
I'll ask the same question with regard to the land development plan. Is there anyone here to speak regarding the land development plan application? Again, I see no one. With regard to the land development application, there has been an application. As I indicated to you, it was reviewed by the Planning Commission on October 25th, 2022. Revised plans were submitted. Those revised plans were submitted by were reviewed by the township engineer, who wrote two review letters dated December 12, 2022. Based on that review, the plan returned to the Planning Commission on January 3rd, 2023. And as I previously read into the record in the conditional use hearing, at the conclusion of that review, Mr. Lyons, on behalf of the applicant, quote, agreed to suspend the clock and present an updated application at the next meeting of the Planning Commission, end quote. And a revised plan has not been submitted, and no one is here to present any evidence with regard to the land development plan application. So first, I'd like to, in the land development hearing, I'd like to review the application, or introduce the application for land development and conditional use approval dated August 8, 2022 as Saldo Exhibit 1. The Planning Commission's minutes of their review of October 25, 2022 as Saldo Exhibit 2. The township engineers review letters of December 12, 2022 as Exhibit Saldo Exhibit 3A, which is the engineer's review of the land development plan, and as Exhibit 3B, the engineering / drafting detail review. So there are two letters that make up that review. As Saldo Exhibit 4, the Planning Commission's meeting minutes of January 3, 2023. And finally, as Exhibit Saldo 5, Mr. Lyons' letter of March 2, 2023, granting an application, or granting, I should say, an extension to the township to review the conditional use and the land development plan as through April the 30th, 2023. The rules on action on land development plans are a little different than they are on conditional uses. With regard to the land development plan, the applicant must demonstrate compliance with the zoning ordinance, all the zoning ordinance requirements, and the Saldo requirements, subdivision and land development ordinance requirements. And the township is required to write a decision if it intends to deny the application, in which it itemizes the sections of the zoning ordinance and the subdivision and land development ordinance which the application does not comply with. So I would request a motion to deny the Tretton Farms land development plan based upon the deficiencies in compliance with the zoning ordinance and the subdivision ordinance itemized in the township engineers letters of December 9. Well, I'll correct myself. The review letters December 12, 2022, when I misspoke. The engineering drafting detail letter is dated December 9, 2022, and we'll make that amendment to the identity of the exhibits, as well as the deficiencies noted in the Planning Commission's review of January 3rd, 2023, and those itemized in the Bucks County Planning Commission's review. So with that, I request a motion to deny the plan for the reasons that I have outlined.
I'll make that motion.
Second.
All in favor of denial?
Aye.
Aye.
Thank you. That completes the review of the Tretton conditional use approval and land development plan. I should have said conditional use application and land development plan application. Thank you.
All right.
You can stay for the meeting.
All right. We'll restart back at the beginning of the agenda now. Back to emergency services, which I see no one from emergency services here. On to old business, the headquarters road bridge. We don't really have much of an update other than we're just continuing on with trying to schedule the investigation of the existing bridge with regards to the piers on the back of the structure of the bridge. We're expecting to potentially do that investigation work sometime in the May timeframe. That's all the updates we have at this time. On to new business. We need authorization for any available fire police to assist Haycock Township on Sunday, May 21st, 2023 at 6:45 a.m. for the Independence Triathlon, and August 6th at 7 o'clock for the Steelman Triathlon at Nockamixon State Park.
I'll make the motion.
I'll second.
All in favor?
Aye.
Aye. The 2022 real estate tax. So, well, I guess Terry, you give a little bit of background, then we could go through the discussion.
As many people know, we've had some issues with our prior tax collector. I'm happy to say that our new tax collector is making up for that with our residents. But we are trying to address ways to handle potential undeserved penalties with the county right now. There's ongoing conversation about what we need to do and what the county needs to do. But just as an update, we're working on trying to solve the problems for those residents that unfortunately were affected by the tax collector that was elected in 2022.
I think
2021.
I think it would be
Well-
helpful to say that the township is going to develop a affidavit form. And anyone that believes that they should have their penalties abated because of the actions of the tax collector. If you paid them late, too bad, you've got to pay a penalty. But if the tax collector didn't deposit your check on time or whatever, what you need to do is submit an affidavit to the township. We'll have a form by the end of this week for you to request, fill it out, submit it, sign it, submit it to the township, and then the township will forward it on to the county, because it's not the township that has the ability to waive the penalty. It's the county that has to act to waive the penalty. So the township will submit your affidavit to the county, and then the county will make the determination as to whether the township penalty and the county penalty, and I suspect somebody will be doing something similar at the school district, although the only issue facing the township are your township taxes. The township has absolutely nothing to do with school taxes. So on the affidavit, you're only going to be asked why your penalty for township taxes should be waived. You submit it, that'll be submitted onto the county, and then it'll be up to the county as to whether or not the penalties will be waived.
Good. Hopefully that will help out some people who got unfairly penalized for, some of the downfalls of our previous tax collector. On to announcements. We have Tinicum Earth Day Fair from 10 to 2 p.m. on April 22nd. The rain date is Sunday, April 23rd. We did have the Park Beautification Day at 9 to noon this past weekend. I guess, Eleanor, you want to go through how that went?
It was a huge success, and I just the board wanted to acknowledge the extra effort, I guess, that was that made it such a success, particularly Terry Johnston, who's the chair of Park and Rec, Terry Lewis, who bought the flowers to be planted by the sign, members of our planning commission, including Neil Sullivan, John Clement, Carl Rothart, John Cole, Ed Bassford, who's also a member of our Park and Rec committee. He was there, as well as Cindy Gaspari from the EAC, Eric Hinrichs, chair of our zoning hearing board, and then members of the community, including Craig DeGroot and Adam, Harriet, Samuel, and Madeline Meshkov. So the park is looking fabulous, and we're hoping that everyone joins us this coming Saturday from 10 to 2 for Earth Day.
Thank you. I guess we have a resignation from the EAC. Michaela Fasson is resigning, and we will be having an opening. I guess so if anyone is interested in being on the EAC, please submit a request, a volunteer form to Terry and the environmental committee for the township. Yep. On to grant subcommittee. I guess this is, Eleanor, something you want to bring up?
Yeah, so I was reading the Herald last week in the April 6th edition, and there was an article that highlighted state grant money that flowed to townships and municipalities throughout Bucks County in the month of March, totaling $11 million, which is significant. And it occurred to me that here in Tinicum, it's, we don't really have a mechanism in place for kind of envisioning what projects we might want to seek funding for to improve, really any aspect of the township. So I was thinking, if we had a subcommittee or an ad hoc committee that was comprised of a representative from each of our existing committees, so someone from Planning Commission, someone from the LPC, EAC, Park and Rec, and if those folks and perhaps additional, it doesn't have to be exclusively existing volunteers for the township, but so there could be additional people from the township with, excuse me, who might bring additional knowledge to the conversation or experience. If this group were formed, they could meet and kind of brainstorm what we might want to do, so that we can then, the board could decide if there are projects we want to pursue as a community and then apply for grants. So, when I see all this money flowing to other municipalities, I wonder if there are missed opportunities here for Tinicum and how we might be able to kind of close that gap and envision, something a little different in the future. So I guess I'm asking for a motion to form a subcommittee that would be comprised at a minimum of a representative from each of the existing committees.
I guess my one comment or maybe suggestion would be possibly to maybe reach out to each one of our current committees and get their input on that and see that we have volunteers from our own group. Maybe try to request that by the next meeting and then have a little bit of a basis to go through of how big of a group we'd have and what ideas they would bring. Maybe see what our group was, because I would like to see, I guess, I'd be more inclined to have it be maybe exclusively part of the committees that we have, as they're the ones who are the most familiar with what's going on and what things could be done in the township, opposed to just, I guess, someone else from
I think
outside.
it's also important to find out what grants are available through the county. So this committee could help in something like that, yeah.
Yeah, I think that would be like the main, I guess I would envision that to be the main thing, see what grant monies are out there and then bring that information back and say, these are the programs, these are the types of things.
I think instead of identifying grant opportunities and then, coming up with a project where we could then seek funding, I do think that the process more naturally flows when you have an idea of a project and then you go seek funding. So,
I don't
but
think
I'm total.
they're not mutually exclusive, so I think. both could
Absolutely.
work.
Absolutely. And Jim, I wouldn't have any issue with this starting off being comprised of a representative from each of the committees, because for what you said, I mean, there are folks who are more intimately involved in what goes on here in the township, and they have a close pulse on what might be happening.
So I guess I would propose that we want to see what, what our committees, our subcommittees currently, what engagement they would be interested in for this, or.
I think that's reasonable. I mean, I like the idea, to be honest with you. I think it's something that's well worthwhile. But maybe we just need to make sure that people are interested in what they're going to bring and who wants to be part of it.
That'd
I
be,
think give us another couple of weeks. We have May 2nd, another meeting coming up. And at that time, we can formally adopt it.
yeah, I guess that'd be my concern, just to see what involvement we have, and maybe we do have to look for outside volunteers, depending on who we.
Like what interests we have.
Yes,
Mhm.
Exactly.
Okay, that's fine.
I would like to see that.
So just one question about timing and then.
Mhm.
So our next meeting is in 2 weeks and not every committee is going to be meeting by then, but I'm not trying to put this off until June, but. Do you think the committees need to have a meeting to see who would be on there, or do you think this is something I can poll with email to the
Yeah,
committees?
I think an informal email poll,
Yeah.
just, just to see what who's
Who's
interested?
Yeah.
Thank you.
I think we had,
I think we have a couple
two questions. Over here first.
No, no,
Oh,
you have
you-
to,
you
you have
gotta-
to come up here and announce who you are and everything else. No, no, no.
You
It
got
has to be on the video. That's the problem.
yeah.
Yeah,
Yep.
you'll see a little button at the bottom there of the microphone. See a little,
Mike turns red.
So the Historical Commission would definitely like to be involved in this, and also the Tinicum Civic Association. We've been asked for some access to grants for mill maintenance, for instance, the Stover Mill. So this has been an item that has been going on for several years, so definitely we would like to be involved.
thank you.
Awesome, thanks.
I'll basically second that coming from the LPC's perspective. And I think across all the various committees, I think there's significant overlap in some of our interests and objectives, like, for instance, with the Historical Commission, and I think the LPC in preserving some of, our scenic history and our cultural heritage, there's overlap there with the EAC as well. So I think a lot of our committees have overlapping interests, and it would be good. What I don't see happening a lot right now is kind of intercommittee discussion about like greater objectives for the township. And I think that would be really wonderful to, I think, enable that through some larger projects that maybe we can work together for grants for. The other thing is that I think what's maybe lacking, or what there's a need for, is that we don't have the resources within the committee, because we have our own things that we're pursuing, right, to pursue these grants as well. So like I'm aware of at least 3 or 4 different grants in terms of land preservation that I'd like to be able to pursue for the committee that would bring additional funding in that we could use at the township. But what we're really lacking is someone that can help. And I think my proposal would be that as we seek maybe other members for this committee, that we would bring someone in that really has, maybe some experience in grant writing, something like that, that can help kind of form our thoughts and our needs into applications and follow through with those applications. And just something that I think that's where some of the need is. I'd like to be able to pull additional money in so that we can use in the township. I don't want to lose out on that to other townships that have pulled the resources.
No, that's a good point about trying, if we could get some volunteers who have some experience, because again, the staff at the office has had some experience, and, Doug has gone through and did grants that he's aware of for the work that he does with regards to the roads. But we have had, one for the Tinicum Park that we have, that was put together by a group of people at one point. And I know that Terry really pushed that across the finish line, being the only person in the office. So anything we would need some help to go after, because we
Right.
do have limited staffing here. So that's a good point.
Thank you.
Thanks, Luke.
And actually, if you look across all of the committees within Tinicum Township, we have a lot of grant writing experience within the committees. So, for instance, I've written innumerable grants, so we have a lot of people that have grant writing experience. It's just a matter of finding out who they are and then asking them if they have the time available to do that.
Thank you.
Thanks. All right, so we'll poll our groups. We got a couple answers tonight, and then we'll see who's interested, and rediscuss it at the next meeting. Moving on to regular business, the minutes of April 4th. Do I have a motion to approve as written?
I'll make the motion.
I'll second.
All in favor?
Aye.
Aye. The treasurer's report and budget recap for March will. All right, we have it, and it is posted. And it is posted on the bulletin board. Payroll report, period ending. I'll make a motion to approve the payroll period ending April 7th, 2023, in the amount of $33,692.40.
I'll second.
All in favor?
Aye.
Aye. The disbursements. Take a moment to review if need be. If there's no questions, I'll make a motion to approve as written.
Second,
All in favor?
aye.
Public Works, we have to award the seal coat project.
The Public Works Director and I opened the bids publicly as advertised yesterday, and then we checked all the documents we needed to check. We had two bids for the seal coat. Asphalt Maintenance Solutions came in at $1.66 a square yard, which adds up to approximately 114.7. Asphalt Industries came in at 1 penny 797, so basically $1.80 a square yard, coming in at 124,203.25. Doug and I did double check, as this is maintenance, but it's over $100,000, and it's usually not, due to the square yardage that we wanted to do. We double checked that as it's maintenance, does it need prevailing wage? And the answer was no, as seal coat is maintenance and not a project. However, I would like to check again. And so I would suggest, if you want to award the low bidder, that we just simply award it as the square yard price, which allows Doug and I to adjust. I just want to check one more thing.
Well, let's hold off because we don't want to award something that was priced without prevailing wage.
No, this bid was advertised and we need to award, but you don't have to award because the bid was advertised, that we can go with the mileage changes as needed to
let's
meet budget. All you have to
Oh,
do is
okay.
award by the square yard.
Okay.
If we can do the whole thing, and I believe optimistically we're going to, but I did not have time to make that one last call I wanted to make today.
Okay.
I believe we're going to be fine with doing the entire sector. But if you simply award it at the square yard price, we have language in our bid that allows us to adjust the square yardage.
I have one question. Terry, do you have what the price was last year?
Yes,
What
last year
was-
we awarded the bid, and believe it or not, it was only a penny less a square
okay.
yard. The big jump was the year before.
Thank you.
You're welcome.
All right. And who was our low bid again?
Asphalt Maintenance Solutions
Okay.
at $1.66 a square yard.
All right. I'll make a motion to award to Asphalt Maintenance Solutions at $1.66 a square yard.
I'll second.
All in favor?
Aye.
Aye. On to zoning. We have this is
That's been taken.
oh, this is out.
Yeah.
No.
The VOS chemical, that thing has been removed.
Oh,
Is
that we just got that
Yeah.
email. Today. Okay. I guess that is on your agendas there, but the zoning hearing board application 2023-1 of VOS has been withdrawn. That was just today. We already went through our subdivision in land development for Trenton, and we are on to the scheduled hearing for the division 2023-1, which is a minor subdivision of Luck.
Hello? John, if you can go up there, it'd be helpful.
The camera's facing this way. So if you hit the-
Just hit the button on the bottom. Okay, and announce yourself again,
All right,
please.
my name is John Hartzell. I'm an attorney in Doylestown. I represent Donna Locke in her application for this minor subdivision application. With me is Adam Cruz, who is our surveyor, who has prepared the plan. Adam?
There's also a copy of everything right
Ready? Yep, I guess we see what your presentation.
Press this again.
No, you're good, as long as that.
Red means go in this case.
Yeah, okay. I'll turn the floor over to Adam Cruz. He'll brief you on the application.
Good evening, everyone. My name is Adam Cruz from Cruz Surveying in Pipersville. And the property in front of you this evening is it is a 39-acre property with about 29 acres on the west side of Center Road and 10 acres on the east side of Center Road. This is a 2-lot minor subdivision. And the property has been 39 acres and has been split by Center Road since Center Road existed. And the application before you is simply to split the properties as they are physically split by the road currently. This subdivision, as a minor subdivision, is not proposing any improvements on either property. However, there is interest in the 10-acre property, which is east of Center Road. And has been some preliminary permit applications made to get feedback from the zoning officer about various variances that may be required if they proceed with any kind of construction on that property. We have the Wynn Associates letter of February 21 of this year and the Bucks County Planning Commission letter of February 27. Also, at the behest of the Planning Commission, we have recently submitted a revised waiver request letter with a little more detail as to the sections of the subdivision ordinance we're seeking waivers from. I'll go through them in a little more detail, but in summary, they relate to things such as road widening, curbs, street signs, encroachment map showing grading on all lots of the subdivision, and some other plan items like that. So about the properties. The east side of Center Road has slopes from Headquarters Road and Center Road up to a flat area at the top of the property. I believe it's the Tohickon Creek, runs along Headquarters Road at that location. So there is a floodplain along Headquarters Road there. The west side of the road is 29 acres, has similar topography. There is steep slopes along the roadways, and there's a more gentle open area at the top, which is currently has some fields. Back to the east side of the road, in the flat top of the area and all of the slopes, it's entirely wooded. It is in the RA district, has a 2-acre minimum. And again, we're proposing the 10 acres east of Center Road, 29 acres west of Center Road, divided along the middle of Center Road itself, as it currently sits today. If there's no questions from the board, I'll hit up the Planning Commission letter, the Bucks County Planning Commission letter. Okay. Planning Commission, their comment number 1 was about the requested waivers. And it was a comment really just that the final plan needs to note the granted waivers. Item 2 is sewage facilities planning module, which what we're proposing, and I had a discussion with Steve Ballard, Township engineer, about how to handle this, because there's a little bit of a chicken and the egg going on. There's an agreement for the 10-acre property on the east side of the road. And as part of their due diligence, they filed a sewage facilities mailer. Sorry, let me back up. They filed with the Department of Health to get septic testing as part of their due diligence. Department of Health said, okay, the testing is okay. Now you need to file your sewage facilities mailer with DEP. DEP got the application and said, okay, but we show this as a 39-acre property and as a 10-acre property. You need to hand us a subdivision plan before we'll process your planning module exemption. And so the chicken and the egg is that the subdivision ordinance requires sewage planning. DEP is requiring the subdivision. So something's got to give. And what we're proposing is that the subdivision ordinance has a means in that as part of a subdivision, a requirement can be imposed that prior to development of a lot, sewage planning is required. Steve quoted the, not Steve Harris, Steve Bala quoted the section to me, and I don't remember the specific section, but that's the long and the short of the sewage planning situation. as
Well,
it
there
stands.
was an email from Suzanne Banks at the department to Terry, in which it said, I reviewed the mailer package for Headquarters Road project and have discussed the project with the township. The township considers the parcels and then the two tax maps as a single lot. Since both parcels are currently vacant, we can still consider a waiver for the proposed dwelling. However, the plot plan must be updated with the following language. And then there's a proposed note to be added to the plan that basically says no permit will be issued for the installation, construction, connection to or use of any sewage collection, conveyance, treatment, or disposal system unless the municipality and DEP have both approved sewage facilities planning for the lots described herein in accordance with the Pennsylvania Sewage Facilities Act, and it goes on. I don't know whether you have a copy of that email from Suzanne with that note that's supposed to be added.
I will certainly obtain it. The
You
language.
don't have to obtain
There
it.
we go. Thank you.
But
easy.
that, according to the department, that's got to be added to the plan, and that's the way that particular chicken or the egg gets solved.
Excellent.
I guess that's the egg.
All right, well, that egg is cooked and cracked and we can move on from it then, I suppose. And so that was the only two items in the Bucks County Planning Commission letter. And for the Wynn Associates letter of February 21 of this year. Item 1 comments that there are several waivers being requested. And again, after this letter was issued, there was a planning commission meeting at which they requested a little more detail as to the sections being requested to be waived, which I will go through as soon as I get through the Wynn letter. Item 2 is a notation about sewage facilities planning approval, which Steve Harris, if I need an email, we'll put that note on the plan and get that process rolling. Item 3 is a requirement for dedication of the ultimate rights of ways of both roadways as easements to the township, which we will of course do. Item 4 is a comment that although we requested a waiver of monumenting the right of ways simply due to, as you can see, they are not straight by any means. So it would require a concrete monument at every angle and joint and point of curvature. And you may end up with 40 concrete monuments along that road to no real reasonable use. And as a partial waiver, Steve Ballard recommended that concrete monuments be placed at the intersections of the property lines with the ultimate rights of way of the line, therefore at the outside edges of the property, which is a more reasonable idea in my mind, and we would certainly do that. So it would still be a partial waiver of a lot of monuments within the property itself, but we would be setting concrete monuments at the perimeter where it crosses the ultimate right of way. Item 5 is seems as though there's little notations of a certification on the plan that needs to get changed. And item 6 requests that the net lot area of each lot be included next to the gross lot area in the label of each lot.
Is that a will comply?
Will comply. The waivers we are requesting, I'm referring to my April 6, 2023 letter. Article 4. It's section 411 B13. There's a requirement for mapping 500 feet from the perimeter of the property. And what we've included in the plan set is an aerial photograph, which is generally more illustrative to people as to what exists around the property being subdivided. And so technically that's a waiver because it requires mapping, which is black lines on white paper which is a little hard to interpret sometimes. Section 411C is a natural features map. And although we do have a natural features map in the plan set, an independent wetland investigation has not been performed. We have researched the National Wetland Inventory and are proposing that use of that mapping be allowed instead of the independent on-site mapping. Now, that being said, development of the property would require the independent investigation be performed to ensure that no wetlands are disturbed, or any waters of the US get the appropriate buffers shown from them for development. And if that triggers a conditional use for the riparian buffer or whatever it triggers at a time of either of those lots being developed, that is something for the development phase if it ever happens on either property. Section 411D is an encroachment map. This is a requirement of the ordinance that demonstrates a grading plan for all lots in the development. And this subdivision is not proposing any construction. There's a 2-lot subdivision of 2 vacant pieces of property. And so we can't provide an encroachment map when there's not going to be any earth moving occurring as part of this application. So that we're asking for a waiver of that. Section 411E, planning modules. I would defer maybe to Steve Harris whether this is even required as a waiver, if we can put the DEP's note on the sewage plans so they can issue their waiver of planning, and that would allow the project to proceed.
I think it's just a waiver based upon placing the note on the plan.
Okay, so the waiver still 411E.
Yep.
Putting the note on the plan. Article 5, 507 requires improvements to existing streets. And we are not proposing a Mark Hankin 30-lot subdivision. You know, we're not proposing anything as part of this 2-lot subdivision. And so we're not proposing any street improvements. I don't believe Center Road would look good as a 24-foot wide cartway with double yellow stripes, curbs and sidewalks. But that's me. So we are asking for a waiver of those improvements. Section 519 is a requirement for sidewalks. Again, not keeping with the neighborhood. There is nothing to be facilitated by installing sidewalks along any of these street frontages. Article 6 are more required improvements. 604 is streets, 605 is street signs, 606 is street lights, 608 is sidewalks, 609 is curbing. Again, Article 5 was the design standards, Article 6 is the required improvements. And also there's a Ordinance 124 amended by Ordinance 141 requiring an environmental impact assessment report. And again, there is a resource plan included in the plan set, but because we're not proposing any construction or disturbance as part of this 2-lot subdivision, we're requesting that the environmental impact assessment report be waived because there is no impact to the environmental situation because there's no disturbance occurring. And the overall idea is that this is kind of an administrative subdivision because it's already subdivided, so to speak, by a public roadway. The nature of the 2 properties, whether somebody applied for a house permit on the 29-acre versus the 10-acre, it doesn't change the situation of the properties as they exist today. And that is the end of our waiver list.
All right. I guess I had one comment on the waiver list with regards to the natural features map, section 411C. I know you said that you're going to do the national wetlands inventory mapping to be provided as indicated on the property. I would also suggest that we include our wetlands map.
Correct.
So, please include that on the wetlands mapping as well.
We would certainly do that.
So Adam, I have a couple of questions on the front
Certainly.
page one of that you have up here. You have a table that is titled Resource Protection Calculation for Non-Qualifying Improvements.
Correct.
And it looks to me like this is for the entire 39 acre parcel.
That appears to be correct, yes.
Have you done these calculations for the proposed 10 acre parcel?
I believe that they do exist and they fed into that joint table.
Okay.
And by fed, I mean,
They
they're done
populated it.
independently
Mhm.
and the cells auto-populate into the
Yeah.
summary table.
I mean, just looking at the total areas existing for steep slopes, 20% to 25%, 15% to 20%, woodlands, and then slopes 25 to 30 and greater than 30. It would be interesting to know what the resulting 10 acre property from this proposed subdivision would
Well,
result in.
Yeah, I agree 100. I agree 100% with that. But, and I guess is the right term. I thought that you had agreed to comply with number 6 on Steve Balla's letter, which is net lot areas should be included with the owner area label on each parcel. So my understanding from that is that when a plan comes back, because if the plan is approved by the township, whether it's approved subject to conditions or not, that when the plan would come back to the township for signature, it would have the 29 acres and the 29 acres and the 10 acre lots separate with calculations for each of the natural resource standards for each of the lots.
That is correct in keeping with the definition of lot area. Yes.
So then you're saying
They've got to
you'll come,
do,
you'll
The
come
numbers will
later
be
and
on
give
the
us
plan.
that.
right,
The numbers will be on the plan.
before they bring this plan back to the township, let's just for the purpose of this discussion, say that the plan was approved, subject to X conditions. One of the conditions is that they have to revise the plan in accordance with Steve Balla's letter. So when they bring that revised plan back, it would have lot 1, these are the natural resource restrictions, lot 2, here are the natural resource restrictions.
Just as Eleanor, as a quick,
Yeah.
I did a quick count there just for the areas that are on the maps that's not in the steep slopes. Give or take approximately 2-ish acres.
It's not in this, and not in the steep slopes.
Yes.
And it seemed like those were the acres that were the heavily wooded acres.
Well, all
whole-
of the 10 acres is
Mhm.
what.
When I look at,
Well, I think the area closest to the Potter property is actually the cedar trees up there,
Mhm.
which are thicker foliage than what you're probably seeing is a photograph with the leaves off and it looks thinner because it doesn't have the canopy of the hardwoods.
Okay.
Does that make sense?
yes,
I think Mr. Potter's here and he can confirm it's the cedars that are closest to him. That is a great question. The Board of Assessment, from the beginning of when I was even involved, listed an address which is apparently not a correct address. That's what I know.
Just as a reference for moving this forward, not to interrupt anybody, but we'll ask questions for the audience because they have to come up and talk at the mic. So sorry, but this is the way we sort of have to do it with the camera.
Yeah, the Board of Assessment lists the address as 333 Headquarters Road. And that's the address that's been on the application.
So back to your original question. Yes, the slopes on a per lot basis will be provided prior to plan signing.
Any more questions, Ellen?
It's not really a question, it's a comment. I mean, repeatedly, Adam, in your letter, including the most recent one from April 6th, you kind of go out of your way to emphasize that this is administrative. We're not going to do anything on this land in this application. Nothing will be disturbed. There will be no improvements or alterations in this application. But you're kind of asking us to kind of suspend or ignore what we know, which is that the intended buyer has already applied for and been denied driveway permit, building permit, stormwater management. So I'm struggling with that a little bit.
And
Do you want to speak to that?
if that individual proceeds with purchasing the property and proceeds with the plan that he's thinking of doing, he is fully aware that if whether he buys 29 acres or 10 acres or property elsewhere in the township or not in the township, he would have to comply with, if he crosses steep slopes of the driveway, he needs a variance. If he does something, if he disturbs more than, let's say, 20% of the woodlands, he needs a conditional use. Those are facts that I hope everybody in the township knows about their properties. We do enough work in the township. We always tell people that even before they sign a contract with us, that, you will have issues.
Well,
You
let's
will-
be more direct. Is the applicant willing to place a condition on approval of a minor subdivision plan that if they propose to develop the property, that they will be required to comply with all zoning and subdivision, all township ordinances as a condition of the issuance of a building permit?
Yes.
I just wanted to, it's one thing to get up there and say it, but it's another thing to say it's going to be on the plan so that anybody that looks at the plan knows what the condition is, and anybody, if there's somebody who's interested in it now, they may buy it, they may not buy it, but that with a condition and a note on the plan, then everybody's on notice. That's all I wanted to say.
And I think that's a great idea, putting somebody on notice rather than have to research ordinances in their own due diligence.
Eleanor, any additional questions or comments or?
No, thank you.
Public.
I'd just like to, if I could, want to
Sure.
emphasize, counsel, the applicant, just following up just briefly on what Adam said. Keep in mind, this is just an application for a minor subdivision. As Steve said, someone may buy it, a lot, someone may not. That's not part of this application. This is just, frankly, the only line we're changing or adding is the line down Center Road. Perimeter lines are not being changed or altered at all. And secondly, Steve touched on this and someone brought up the issue about the address of the property. Some noise was made about that at the Planning Commission, and I just want to emphasize again, that address came from the Board of Assessment long before, years before this ever came up here.
It's on GIS too, so.
Yeah, it's public record, and I think we're entitled to rely on that, whether it's precisely accurate or not. I think we're entitled to rely on that. To not use that could be construed as a misconception. So I just wanted to make that point. That's where
I
that
think
address came from.
everybody knows where the property is, and hopefully the owner of 333 Headquarters Road hasn't been paying your taxes.
Good, thank you. That's,
John, you're right, but the 300 or the 900-pound gorilla in the room is that everybody knows that after this property is subdivided, there's going to be a house up there. And or there at least somebody's going to apply to try to get permission. And that's why I wanted to be very clear that there would have to be a note on the plan that anybody applying for a permit would have to comply with all township ordinances. Thank you.
that's absolutely correct. And that's the fact. And any applicant, any purchaser is expected to go through and adhere to all those requirements. And that's for a later time. Thank you.
I do want to say one thing as sort of as background, just so everybody understands what the rules are in what the Board of Supervisors authority is or is not in considering this application. The question is whether or not the application meets the requirements of the township's zoning and subdivision ordinance. And there are a myriad of cases that say the fact that it doesn't, and I'm not saying it does or it doesn't, but that arguments that it's poor planning, that arguments that it's not preserving the natural character of the land, the arguments that it doesn't comply with a comprehensive plan. Those arguments are not a basis for the township to be able to deny the plan. If the plan complies with the ordinances, it has to be approved. Now, the township can add conditions to that approval, and that's one of the reasons that I wanted to be clear about the sewage note from the DEP and the note on compliance with all township ordinances. But the issue for the discussion tonight, and the only thing that the Board of Supervisors is empowered to do, is to determine whether or not the plan meets the requirements of the ordinance. So I just wanted to say that as background.
Thanks, Steve.
Vladimir Salamu, as the owner of 333 Headquarters Road, as well as 325 Headquarters Road, I would insist that this mistake be corrected immediately. I mean, I don't see how you can go putting up a plan for a property that's, that's misidentified. 333 is on this side of the stream, not, it's on the south side, not this property on the north side. So.
Thank you. Yeah, I think this probably brought that out in the open, and hopefully, I don't know if that's
I don't think,
I don't know how
that
that gets corrected. but-
well, there are two aspects of this. I don't think that the plan itself identifies the property as 333 Headquarters Road. You know, Adam?
I don't recall putting it on there.
Yeah. So I don't think the plan does that. The mistake is the Board of Assessment. And it would seem to me that you're probably the person to write the Board of Assessment and say, I'll give you the board. I mean, I don't know that, I mean, maybe the township can do it, but here's the, I looked it up too.
Steve, I don't think that it should be on the Solomons. I think it should be on the
It's
applicant.
their burden, not mine. And besides,
I agree
I
with
don't
that.
even think that is across from 333. I think it's across from
Well,
335.
Here, John, here is the record from the Board of Assessment, and well, then, we will, as a condition, if the board was prepared to approve this as a condition of approval, would you agree to write a letter to the Board of Assessment to correct the address of the property?
Certainly.
Thank you.
Any other comments, questions?
Thank you.
Kathy?
Catherine Auerbach, Center Road. A question, as Steve was inferring or referring to the fact that the township's responsibility is to make sure it meets the zoning requirements and things, but if it's as the 39 acres non-conforming property, is it in the zoning to allow you to subdivide to create two non-conforming properties that will require variances if anything else is done, but then you're creating something that you shouldn't be allowed to grant a variance on something that's a self-imposed hardship that the creation of this is then creating something that has to go for variances.
Just to answer
How do I
that,
explain it?
which is makes a heck of a lot of common sense. But the same issue arose up in Solbury Township. Similar kind of a lot that you couldn't get to and develop because of steep slopes. And the argument was made that because you needed variances to develop the property, that the hardship was self-created. And the court said the mere fact that an applicant for a variance purchased the property with knowledge of the hardship does not preclude him from being granted the variance. The mere fact that the property changes hands after the adoption of zoning cannot be the basis for holding that no variance can be thereafter granted with respect to any matter of which the purchaser could be aware, because zoning considerations relate primarily to circumstances of the property and not to the identity of the owners. It would seem that subsequent purchaser could stand in the shoes of the original owner with respect to a variance. And so I understand exactly what you're saying, and that argument has been made a number of times, and the court said no, just because you know that you need a variance doesn't disqualify you.
Yes, but that might be talking about a single property, not one that has been now subdivided. So it may not be matching exactly an application,
Okay.
legal application. You're creating something. You're creating something that will facilitate septic approvals. So you're knowing that you are encouraging further investigation to develop a property that has multiple overlays, that's next to the EV stream and the Urbana Historic District, it's scenic corridor, all these things. And that action goes sort of in contrast to all the other aspects of what the zoning, your township comprehensive plan or goals are. Certainly, you're not supposed to consider that, which seems kind of silly, but you do need to consider the fact that you are consciously splitting and creating and facilitating further action that would encourage the development of a property that currently is a larger tract under certain conditions. So I question whether or not, I think that you could deny it, because if you're not comfortable with this moving obviously forward to a development application, and that what you're doing would help to facilitate that, and is creating a new non-conforming lot, I don't feel that that's a good action for the township to take.
Thank you.
And one other thing is, many of the people on Center Road have a right to a spring, which is right down at the point where these two lots, presumably, or the whole lot, meets when Center Road comes out to headquarters. So that's another aspect of your need to consider what things are being impacted that impact a greater community than just those two lots and the owners of those two lots, or one lot. The one lot.
Kathy, when you say that other owners along Center Road have a right to access a spring that's in a corner of those properties at headquarters, can you be more specific? What do you mean a right?
I believe it's in some of the deeds to a right to go down and access and take water from the spring that's at the bottom of the road.
So Steve, how would that be affected if there's
Well,
a subdivision and then there's a transfer of ownership?
If there is an easement or rights to a spring, the subdivision does not remove those rights any more than the sale. If the property owner sells the property, the whole property together to somebody else, if there are in fact property rights to use the spring, those rights continue.
Yeah, it's okay, but I just want to keep in mind.
I mean, I think it's very important that be brought out in case you know, I have no idea whether the prospective buyer is here or not, but the point is that, that's the first time I've heard it, but equally, the point is that the rights to, obtain water from that spring, if anybody has them, they continue them. They don't lose them because the property is subdivided along the center road.
No, yes, I would hope that be the case, and it's just a matter also that any actions that would encourage grading or development or changes of the nature of that landscape, especially closer to that spring, are then, that you're facilitating more issues that are impacting things that have a broader base.
Well, I
There's
guess.
no, there was nothing in the property owner's deed, because, you know, they're part of the application. It makes reference to that spring and the right to use that spring. And that's, and I also have the initial deed into the current owner, Mr. Burrow's deed. And it does not, all I can say is that deed does not make any reference to somebody else's right to use a spring on the property. Now, maybe there are some other agreements out there, but at least the deed from Mr. and Mrs. Burrows to the current owner is not under and subject to anybody's right to use that spring. I'm not saying it doesn't exist, but it's not in the deed.
Mr. Hartzell,
Thank
you
you.
were nodding, yes, that's correct. Can
I
you,
agree with Steve's comment in that if there is something on record, aside from that, that gives neighboring property owners the right to use the spring, that has nothing to do with this subdivision. If those property owners, those neighboring property owners would still have right to use the spring, whether the property is as it is now or whether it's subdivided into two lots. It wouldn't affect this at all. It would be, if it's on record and they have a right, this will not affect it or extinguish it. If it's on record and my client, the owner, when she bought the property, she bought it subject to those rights, which would continue on in existence.
where would it be on record?
If it's on record, it would be at the recorder of deeds office,
Would it be on a deed?
not necessarily.
Okay.
It could be on, not necessarily the deed to this property, it could be on a deed to one of the neighbors' properties that they had a right to use the spring on this property, but it wouldn't necessarily be on this deed,
Right.
but it won't be affected.
No, it won't be affected per se,
No, it
but
won't be
your
affected.
action will encourage the development, which then could affect it. So
Well,
that-
I
it's
guess
just, it's stretching that, but I just want to keep you
No,
aware of the.
Yeah, I think that's a good point.
I mean, I guess the one point that I'll bring up, and there's a couple examples that we just dealt with that, you know, just because this lot potentially gets split doesn't necessarily mean there's any more potential than if it was to stay for both sides to be developed. Center Road had a property that just got subdivided that had two houses on it. That was 20 some acres that just got rectified. And we just had another property that just had a single house that had another house built on it. So there, you know, potentially there could be two houses built on this property on either side of the road, regardless if it gets subdivided or not either. You know, because both of those had to go, well, the first one, it was the opposite, taking away the two properties and making them individuals, but the other one went through a variance to get the second one built, which was, you know, ultimately granted. But, you know,
Well, the other thing, I guess, I don't know how variances work if you're creating the issue for the variant, you're creating the condition for the variance, basically. So is that a steeper threshold? Like you may not get the granting of the variance because you've
There's no
created a problem.
guarantee. There's no guarantee.
As opposed
Yeah.
to buying something that has, you know, some situation that you go, my goodness, I can't do anything here because, but if you're creating that situation, that should be a higher threshold as far as
Well,
granting.
the answer, in order, well, number one, if the board approves a subdivision, that does not guarantee that a future owner will be entitled to get a variance to build on that property. You have to meet the standards for a variance. The first is it has to be a unique topography that prevents the development of the property. And I think most people would agree that exists. Then the question is whether or not it's necessary for the reasonable use of the property. Then it has to be, and this is a critical one, it has to be the minimum variance that will permit the development of the property. So, somebody says, well, gee, I want a 4,000 square foot house where a 2,000 square foot house would fit. Doesn't mean they automatically get the house or the driveways or anything else that they want in that regard. It's the minimum variances that will allow a reasonable use of the property. Then the fourth requirement is that the variance cannot be self-created. And that's the issue that I read about that case, that just because somebody buys a lot that's going to be subdivided and knows that there are problems with the lot, that doesn't make it self-created. And finally, there's a question that the zoning hearing board has to ask is, will it be harmful to the public health, safety, and welfare? So those are the standards. Those are the tests that would be applied if somebody buys the lot and wants to build a house on it. Those would be the tests that the zoning hearing board would apply in determining whether or not somebody's entitled to a variance to, put a driveway up the steep slope and build a house at the top of the slope.
So right now, 39 acres, somebody could come in and request to build a house. The minimum might be one house, maybe on the other side, or who knows where. So you're kind of multiplying, you're doubling now that opportunity. You're allowing for two scenarios where there's just one. And so then it's not the minimum. It's not,
Well,
it's
then-
not the
then-
minimum relief because you're now
Well,
giving like,
that's
it's a double reward.
As I said, there's no guarantee that the person who's applying is going to get a variance.
No, I understand that, but it just seems like it's creating more than just the minimum.
Thank you, Kathy. Additional comments, questions? Anybody else? All right, so I guess still deliberation for us. Guess, does anyone want to make a motion with any conditions?
Steve, we're only looking at a subdivision.
That's
Is there
correct.
any law or ordinance that prevents this property from being subdivided based on what was provided tonight in evidence?
Well, I don't think there is. I think that the argument is the argument that Kathy made. Well, you could build a house on one half of this thing, so why should you be able to get a subdivision? But the case law, as I understand it, if the township subdivision ordinance required a zoning permit or required a zoning officer to determine whether or not there could be a house built on this property, that argument may have some merit. However, both Steve Balla and I looked through the ordinance and do not believe that provision is present. So I believe that there is entitlement to a variance, to a subdivision, which would be conditioned upon compliance with the township engineer's letter of February 21, 2023. The sewage note that I handed to Adam that was required by the DEP, that if a person does plan to build a house and gets a variance to build a house, that before a building permit can be issued, that it must comply with all township ordinances. That means not only the zoning ordinance and the subdivision ordinance, but the grading ordinances, stormwater management ordinances, floodplain ordinances. Would have to be compliance with all of those items. Fourth, that the applicant, as a condition of having the final plan signed, will have to notify the Board of Assessment to correct the records of the address of the property, that the applicant will have to pay all of the township's cost of reviews as a condition of the signing of the final plan, and that the waivers would be granted, the requested waivers would be granted, subject to the additional requirement that in addition to the national wetlands map, that the township's wetlands map would also be included on the plan.
Steve, did you include the language from Suzanne,
Yes,
from that email?
yes. Yeah, that's the
That was the
sewage
sound of
note
sewage.
that I handed to Adam.
So since there's no legal or ordinance prevention of this subdivision, as you articulated to us, then I would make that motion to approve this based on all of that verbiage that you just did
All the
with
conditions
regard to
that I-
conditions and everything else, because I can't remember and I wouldn't be able to repeat it all exactly the way you said it.
I would second that.
So I have a quick question. So now the subdivision is being granted subject to all of these conditions as say it changes hands and the new property owner is applying for all these various permits. Has it been subdivided? Or is it only subdivided after they
No, it
comply
would,
with all the permits?
no, it would be subdivided and then it would, if the motion is approved and the applicant goes out and complies with those conditions, the next thing that happens is they bring the plan back. First, Steve looks at it and says, yeah, for example, the issue that you raised about showing the natural resources lot by lot, that has to be done. The changes that were suggested with regard to the language of the certifications has to be changed. All those things have to be changed, and assuming that they are, and Steve says, yes, the revised plan meets the requirements of the approval, then it would be signed and recorded and the property would be subdivided. If the property then changed hands and the new owner wanted to apply for a variance to build a single family home on the property, then they would have to apply for that variance. If they received the variance, then they would have to apply for a building permit and demonstrate that they comply with all of the township ordinances before the building, any building could begin.
Any more questions?
No.
All right, call for a vote. All in favor?
Aye.
Aye. All right, thank you.
Thank you for your time.
All right, on to public comment, not related to anything else that was on the agenda. Have any takers? Nope, seeing none, I'll make a motion to
Hold it,
adjourn.
hold it. She's got something here.
Nope,
Not
okay.
that I want to have to amend an agenda, but late this afternoon, I received a quotation from Sullivan Building and Design to design our addition and ADA bathroom. The It's not Neil Sullivan, but Sullivan Designs Engineers. And I'm not asking you for a motion tonight, but I'm going to ask you, I'll put it on the next agenda if possible. But it looks like it is, I will send that to all of you, but I wanted to consider it would be approximately $4,000 to go forward with getting a design that we could put out for bid.
And and this would be part of the for lack of a better term, the COVID funds that the
The-
township got.
The improvement of the township
Yeah.
offices.
Yeah,
Yeah.
all through that,
Right.
400 some odd
So I'm
thousand
gonna
dollars
just
that we got.
distribute that. I guess I don't have to amend the agenda because I want them and Steve to be able to read this. I
You're
have-
not asking for approval tonight.
No.
You're just
That's-
notifying the
no.
board
Yeah.
and the public.
That's my,
That doesn't need to
okay. all right.
amend the agenda.
Thank you.
So I actually have something
Okay.
before we adjourn. So over the weekend, actually, when we were at the park, cleaning up the park, I received an email from the executive director, I think she is, from the Bucks County Association of Township Officials. And she, I was on the recipient list because I'm on the infrastructure committee for that organization. So and pardon my looking at the phone, I didn't print this out. So the email was an invitation described as an opportunity to join a regional application for EV charging stations. The Delaware Valley Regional Planning Commission is preparing a regional application to the Federal Highway Administration Charging and Fueling Infrastructure Program. And one township was invited to participate. The DVRPC reached out to Picado to see if there were any other municipalities who might be interested in being a part of this regional application to have charging stations throughout Bucks County. And the reason why I'm adding it, kind of just commenting on it now, is because they have asked if your municipality is interested, they've asked to just have a letter, like an email expressing interest by tomorrow. It's not like a commitment. We wouldn't have to move forward with it, providing information, but if we want to have our foot in the door, they need to know by tomorrow.
The short answer is I'd be in favor of that.
Okay.
Yeah.
Well, and I think that since it is tomorrow, that's an emergency. So you don't have to amend the agenda in order to be able
Let's
to
quickly,
take action.
we could do that very quickly.
Okay, so
We-
there's a motion. Eleanor, you made the
Yes,
motion
I'll-
that we apply for this.
Oh, yeah.
No,
We'll
we'll-
do not get a motion in a
Send
second
it,
first.
So I'll make the motion. Sorry.
To send our
To
interest letter.
join the DVRPC's regional application for the CFI program on behalf of Tinicum Township.
Right. It's an interest letter, is that correct? Showing.
It's just an email saying, yes, include us.
I'll second them.
All right, comments?
Steve, get them all. So we've been doing some research at our firm on this kind of stuff. And we're finding that a lot of charging stations across, well, the few spots that they are in the country are going without repairs and breaking down and et cetera, et cetera. There's not a ongoing maintenance program that anybody's really sort of supporting. Like, I guess I'm old enough to kind of remember what, and maybe some of you guys are, when they started just building out gas stations. I mean, now they're everywhere. While I was everywhere way back when.
You were around with, they were just building out gas stations?
Wow. I read about it.
It's incredible.
I read about it. Rumors had it. That, you could, roads that years later you could drive on and there's one every 2 miles. You had to plan a trip to the shore, like thinking like, I need a quarter of a tank because you can't get, there was no gas station from here to there. So the EVs are not even there yet, right? So my question would be, before you guys were to, I mean, you're going to do whatever you're going to do tonight because of the emergency notion of it, but you should ask the question of who's going to support this thing? Because if they just build some wrecks that are, you put them in there once and then 6 months from now or 2 years from now, they're just ghosts, and then we have to respond to
Steve,
them.
we're way ahead of that. This was a letter of interest and that's what I asked her specifically. It's just an interest letter. but there is all lots of things. I'm aware of the EVs breaking down. Who's going to be maintaining them? Who's paying for them? They're going to be a pay as a service. There's a lot of questions with this, but not to lose the opportunity to get the grant, which we talked about a little bit earlier.
Right, you
It's-
put that
it's
opportunity
good to-
close perhaps, right? So
Exactly.
that's,
Yeah,
that's
yeah.
really what I'm saying.
Yep.
Right.
No, it's all in the details.
Yeah, okay.
Thank you.
Thank you.
And the other matter that I wanted to raise, and I don't know if it even needs a
Well-
motion.
Well, is it? Yeah,
I'm sorry.
We
Forgot.
didn't close out
Yeah.
that.
Yeah.
All in favor?
Aye.
Thank you. So the other matter was, over the weekend, there was a big article in the Philadelphia Inquirer about, a municipality in New Jersey opposite Marcus Hook. So kind of just south of Philadelphia and in New Jersey, and about how, a developer is looking to open up develop land, agricultural land for 9 additional warehouses in this municipality. And the article talked about kind of the pressure that that community is under from warehouses. And I had forwarded it to Terry. And then today or yesterday, there was another article in the Philadelphia Inquirer, and this time it focused on, I think it's on the front page of the Inquirer, and it focused on the Lehigh River, which is now among the top 10 rivers in the country at risk for severe degradation because of the build out of warehouses throughout the Lehigh Valley, which is now moving kind of north along the northeast extension. So I'll also add that a couple of months ago, I went to a seminar where there was the executive director of, I think it was the Lehigh Valley Regional Planning Commission, and she had indicated that there was no more land basically in Lehigh County that is not already under agreement with the intent to develop for warehouses. So, kind of looking at what is happening around us, I would like to have our planning commission have a look at our ordinances to see if we can, refine anything that addresses warehouse use.
I mean,
Do we need a motion for that?
No, this is sort of, because we had this discussion, somewhat related to this because of the one development that we have, but it was related to our industrial use, which has myriad of uses included in it, which they so chose, and that opens it up to a little bit. I think we had tasked the planning commission maybe trying to fine tune that or break that out, or maybe break it into industrial ABC, something to reduce the, if you pick one, you don't get 10 option. So maybe you could piggyback on that. Because that would make.
It's that old problem. Now, the 1 million square foot warehouse problem, which is Lehigh and that Marcus Hook was on the television this morning, is its own problem. But at the same time, you've got to make available all types of uses, or else you wind up, getting a curative amendment for some use you don't like. So on one hand, you want to be selective. On the other hand, you can't preclude a legitimate business.
I
And
think,
I think that's always the balance that gets so much discussion in these kinds of issues, because obviously there are concerns about what is and isn't permitted, and you can have reasonable restrictions, and what's reasonable in the view of one person is unreasonable in the view of another.
Yeah.
So it's
What
an
is-
interesting balancing
What
act.
is our industrial area here in Tinicum? Isn't that the area over by 611 and Bedminster Road there?
Yes,
Is that our only area
Yes.
that's
Yes.
industrial in our township? Carl's here with PC. Carl, you aware of any other thing that's zoned industrial?
No, I'm not sure if many warehouses are allowed anywhere else, but it would all have to go into the planned industrial.
Right.
Yeah.
So it's very limited as it is right now. So I guess what your concern is that something will change to make it grow? Industrial?
In terms of where they
The
might
zoning?
go.
Yeah,
Well, no, I mean, my concern is we still have undeveloped parcels in planned industrial, and
that's planned industrial?
In planned industrial, we still have undeveloped parcels.
Is that the part that I'm just talking about, or 611 in Bedminster?
Mhm.
How
Yeah.
many acres would you say? Are you aware? of?
Mhm.
Well, does that prevent that?
No, it does not.
It doesn't. Okay, that's good.
No,
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 he's-
if
he
it's,
said-
if it's subject to an agricultural conservation easement, you could not put a warehouse on it. But if it's simply in the ag security area, that doesn't prevent development.
Ag preservation, not.
Okay, so the larger
Okay.
parcel you're talking about is ag preservation?
Well, then, if it's subject to an easement, it couldn't be developed.
Right, well, that's already under 30 acre plus. I'm sorry, what? Directly across the street from the Spinio application? Okay. Okay,
But yeah, there's.
Yeah.
so there's a limited amount of industrial acreage, but okay.
Yeah, I mean, I think it's not a bad idea to, you know, see if we could tighten it up. I think one of the bigger things is to take our industrial park area and, you know, again, when you pick one, you pick one. That's probably the biggest hole that we have at the moment.
But quick comment, kind of tying both things together, going back to the ED and somewhat with our zoning. So,
Is the mic, yeah, it's on.
the, gas with convenience use, which I think when I was looking through the codification, it got our LC district, which is like limited commercial, it got added to as a allowed use in that district. And I find it kind of interesting because that's supposed to be non-customer based businesses, not like, a consumer type experience business. And I wonder about future thinking, right? Eventually this gas station with convenience is going to, maybe it morphs into charging stations with convenience, but I think we may want to think about, how we kind of word some of these uses for the future where, maybe they had a convenience store, maybe the gas pumps closed down. Now it's just a convenience store. Is it still like gas with convenience anymore? Is it still like, how do we think about how the world may change around some of these uses when we go more to EVs, and just thinking about that in terms of our how we've defined some of the allowed uses.
I think that's what Jim was saying, that maybe the
districts,
PCs
yeah.
take a look at that.
Yeah.
Want to define it a little better.
Yeah.
Yeah.
That's it.
Thank you. All right. On to adjournment.
Make the motion to adjourn.
I'll second.
All in favor?
Aye.
Aye.
Thank you.
Meeting
all for
adjourned.
coming.
Thank you.
This was all Terry's fault. The meeting was over until